This is a slap in the face to not only this mother and family, but to all of us. And we pledge out of National Action Network at our national convention that we're going to the Justice Department to review this case. There cannot be the allowance of no-knock laws nowhere in this country, whether it is this case or whether it's Breonna Taylor. It's all because we're dealing with states' rights legislation around no-knock law. This young man was in his own home, laying down with a licensed gun, and he is killed. And their defense is self-defense. How do you defend yourself in my house when you don't have a legal right? The warrant did not have his name or apartment there. What are you defending yourself against? Breaking and entering into my house? So it must be federal law. And we want her to know that we're going to stand with her and go to the Justice Department and demand they review this. This is not over.
Welcome back. That was Reverend Al Sharpton at a press conference earlier today reacting to the news that there will be no charges filed in the death of Amir Locke. If you remember, Locke is the 22-year-old who was shot and killed in February while the Minneapolis SWAT team was performing a no-knock search warrant for someone else. The incident was captured on body camera video and was released not long after the shooting. Take a look. After reviewing that video, along with all the other evidence, Attorney General Keith Ellison, along with Hennepin County Attorney Mike Freeman, released this statement today saying there is insufficient admissible evidence to file criminal charges in this case. Specifically, the state would be unable to disprove beyond a reasonable doubt any of the elements of Minnesota's use of deadly force statute that authorizes the use of force by Officer Hanneman. He goes on to say that it would be unethical for us to file charges in a case in which we know that we will not be able to prevail because the law does not support the charges. Now, while no charges are being filed for Amir's death, there are changes being made to the Minneapolis Police Department's policies. Yesterday, Minneapolis Mayor Jacob Frey announced that he has formalized a new policy that will take effect Friday, requiring officers to knock and wait before entering a residence. All right, let me bring back in the think tank to get their take on these developments. Still with me, criminal defense attorney Eklund Mercy, former federal prosecutor Nima Rahmani, and the attorney who represented Jodi Arias and author of the book series Trapped with Ms. Arias, Kirk Nurmi. Kirk, I want to start with you and get your reaction, and I'm going to go around the horn and get everyone's reaction. But first, I want to start off and get your reaction to this decision not to press charges.
Look, ultimately, we heard from Reverend Sharpton, who I shared the disdain for no-knock warrants with, but I cannot agree with his contention that there should be a prosecution in this case. Because when we get to the point where the officers are in this apartment serving this warrant and there is a gun pointed at them, the question becomes, what were they supposed to do? What are they supposed to do in that situation, if not protect themselves? And the Reverend seems to think that, there should be prosecution simply because somebody was shot. And I just do not believe that. The real crime here is the no-knock warrants, and those need to be pulled back. But the idea of pursuing this with the Justice Department still doesn't get past, to me, that question of what is the officer in that situation supposed to do? I don't know that we can hear a reasonable answer to that question.
Yeah, fair enough. And the Attorney General said it's not their job to consider at that time if no-knock warrants were appropriate. Eklund Mercy, what's your response?
I'm disgusted because here's the thing. When does prosecutor's office do offense and defense? That defense, that's a defense. If there's self-defense, that's a defense that should be brought up at trial. So at least let the jury exonerate the officers. Let the jury, let the citizens have a chance to have their say with regards to the facts. The fact that we have a prosecutor who's considering a defense, so now we have prosecutors who are only about convictions and not about the people. Let the people decide. That's why jury selection and jury duty is so important. I don't believe that this was a right call. I do believe that, hey, if there's a defense, then let the officer present a defense and let the people decide if he's guilty or not. But for the prosecutor to take that on by themselves, yeah, I do not agree with that.
All right, Nima, I'd love to get your response to that. It's an interesting argument. In these times, perhaps it may make sense, but your thoughts on it?
I agree completely with Attorney General Ellison's decision here. And let's not forget, this is a brave, just, and aggressive prosecutor who prosecuted Derek Chauvin, charged the other 3 officers, a lot of prosecutors would not, and charged and convicted Kim Potter. So this isn't someone to shy away from prosecuting officers. But in this case, and setting aside what you think about no-knock warrants, oftentimes the officers executing the warrants have nothing to do with actually getting the search warrant. And that's what happened to Breonna Taylor. They're just doing their job. They enter the residence like they're supposed to, and someone grabs a gun. They really have no choice under the circumstances but to shoot. This was the right decision by the Attorney General's office. Obviously very tragic that Amir Locke had to die. That death was completely unnecessary. But this isn't a situation that merits criminal prosecution, Michael.
You know, what I'd like to do now, guys, is I want to actually take a look at the Minnesota statute for when an officer can use deadly force, as it was referenced in that statement. Now, according to the statute, for a peace officer's use of deadly force to be authorized, there must be at a minimum a threat of death or great bodily harm, which, 1, can be articulated with specificity, 2, is reasonably likely to occur absent action by the law enforcement officer, and 3, must be addressed through the use of deadly force without reasonable delay. And also it says the law does not allow for consideration of the victim's subjective intent. So Eklund, I want to go back to you. As far as those 3, in terms of proving those in court or disproving them, the only one that I can see that maybe they could have some issue with is number 2. Was it reasonably likely to occur? That means the deadly force absent action by law enforcement. They did see a gun come out from under the blanket. Perhaps there was a time frame there. They could have waited a little longer. But of those, where do you think the opportunity for prosecution lies?
The issue is a no-knock warrant. You have a no-knock. You got in without a knock. At that point, somebody could yell police or something. When you just run through because you want to go in blazing saddles, that's the problem. At one point, you have to let you know, because all he's seeing subjectively and objectively is lights. All he's seeing is lights and black people that are masked coming into his home. That a reasonable, prudent person would also have the same reaction. We can't say, hey, we have the right to bear arms, but yet and still I can't use mine. When you make a mistake, at one point, they have to, there's like 6 of them in there. At one point, somebody could have yelled police or showed him the warrant. That wasn't done. It's like, what do we do? It doesn't even make any sense.
Yeah, I mean, clearly it's safe to say that Amir Locke would still be alive if it wasn't for no-knock warrants. So there have been changes. Let me go over a couple of those. These go in effect on Friday. Police must knock. During the day, they must wait 20 seconds before entering. At night, they have to wait 30 seconds. There's no-knock warrants have been abolished, basically, unless they're very extreme circumstances. Civilians will be able to review the video. So the question for you, Kirk, is, does that go far enough? Is that the right direction? Because a lot of people will say, especially in the law enforcement community, that puts them at even more risk.
Yeah, you know, it seems like it's a compromise between these 2 opposing forces, and that's ultimately what happens in a democracy, right? We believe in the beauty of compromise. Personally, I believe that no-knock warrant should be abolished simply because of what we see here in Mr. Locke. And I want to advance what Eklund said. Mr. Locke did nothing wrong. He reacted appropriately within his home. Could a knock have prevented this? Maybe. Could that 20 or 30 seconds, whatever would have been appropriate during the time frame, would that have altered the course of events? Maybe. So it's a step in the right direction. I personally would still like to see no-knock warrants abolished, but ultimately this is a step in the right direction, and it is a compromise that serves competing interests, because we certainly don't want a situation where law enforcement officers are put in jeopardy either.
Nima Rahmani, quickly, in the last few seconds, your take on the changes to the no-knock warrant laws.
Yeah, I mean, first I gotta say, I heard police announce themselves several times in the video. And then no-knock warrants aren't necessary. This was a murder investigation. Okay, this isn't some misdemeanor offense. I mean, there was a reason that law enforcement was going in there. And obviously in Breonna Taylor, you use no-knock warrants in drug cases, otherwise the drugs disappear. So maybe limit them, but I don't think they should be abolished entirely, Michael.
All right, fair enough.